Yes.
Regarding the selling property, so if one spouse is incapacitated and the other is not, can that spouse still sell a car, sell a house, or do you need to be away?
So, unless, the question is if one spouse is incapacitated, the other is not, can the spouse who has capacity, can they sell property? The answer is no, you cannot. Because the spouse whose name is on the deed or the document has to sign. So you need a durable power of attorney in order to sell the asset, even though you're married. So this really takes people by surprise. And if you don't have that, then you're going to be under the court's plan. Remember, you either have your own plan that you put into place, or you have the state's plan. If you have your own plan, you're going to have a general durable power of attorney to protect you from whatever life's going to bring. If you haven't taken that step, that action to protect yourself with your own plan, the state's plan is what's in place for you. And if you are married, your spouse is incapacitated, you need to sell your property, and you don't have a durable power of attorney over your spouse, the state will become the decision maker, even though you're married. There will be a guardianship, a court-ordered conservatorship, a guardian, or as of this year, we're now calling it conservator in our state for finances. And everything you do has to be run through the court, everything. So here you are, owner of this property, and you can't sell it because the court has to give you legal authority to sell it. Believe me, that's an extraordinarily frustrating place to be in. It makes no sense for the most part, but that's what our laws are. And this is one of the reasons that I love to do these educational presentations, because I want everybody in the room to know, if you don't have a durable power of attorney with your spouse, and one of you loses capacity, you will be in a court-ordered guardianship, and all of your freedom is gone. Yes?
So does that require two different documents, or can they cover the couple in a durable?
Yeah. Each person should have their own individual document, because you have to sign. I grant authority to my spouse to make decisions for me. He has a document where he says the same thing. And we just talked about why you might want to have a gifting authority and a power of attorney. It's so that we can apply for Medicaid government benefits. So with the authority that is granted comes a whole lot of responsibility. The attorney, in fact, that trusted individual that you've appointed under your durable power of attorney, has responsibilities. They are called a fiduciary, and they have to keep track of everything they do. They can't use money for themselves. They need to use it for the benefit of the principal, the incapacitated person. And when we do durable powers of attorney at our office, we recommend that they take effect immediately, even though you are fully capable. Because if you make it springy, meaning it doesn't come into effect until you lose capacity, then you have to get a doctor or two to sign off on the fact that you've lost capacity. And if you've ever dealt with anybody with declining capacity, it waxes and wanes, and it's difficult to get a doctor to say, oh yeah, mom doesn't have capacity or this or that. So we recommend that they be effective immediately, and you're appointing somebody you trust. You give them the document, you say, I want you to know you're my attorney in fact under my power of attorney, and I'm perfectly capable, so of course you don't need to do anything until you see I need help. And if that's not comfortable for you, then maybe you're not appointing the right person. If you think they're going to step in and start acting prematurely, perhaps there should be another person that you can trust that won't act until they need to help you. And the person, the attorney in fact, they're also called the POA, basically they should be simply acting on behalf of the person who needs help. All right, so I just covered financial powers of attorney. It really is the most important legal document you can have. And as an elder law attorney with Medicaid focus, I often run into problems with the documents that I see from estate planning lawyers. They won't give the authority to do a transfer on death deed or a gift for Medicaid, or a separate property agreement for spouses, or there's numerous authority that has to be specifically laid out in a financial power of attorney, and if it's not there, my hands are tied. And if my hands are tied, then I can't help preserve assets to the extent that I could otherwise.